Don't tread on us. We're not afraid. You work for us. We're not your slaves.
Hello and welcome everybody. This is John Stone at UticaFreePress.com, and today I was going through some headlines and I came across this one in USA Today called Supreme Court Hears Case on Home Searches by Police. Now this happened back in 2005. This is what this whole matter is about in Lexington, Kentucky. And one of the quotes by Kagan, here it is. One of the points of the Fourth Amendment is to ensure that when people search your home, they have a warrant. And of course, there are exceptions to that, she said. Well, you know, let's take a look here. That there are exceptions to the Fourth Amendment. Let me take a look on my phone here. I do have the Constitution handy right here. Okay, here's the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by the oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, I get from that, I don't see any exceptions to that. It sounds like you need sworn affirmation. They need to have some probable cause. They need a warrant issued by a judge, and they have to have an articulable argument to do so. But let's continue so you can hear where this story goes. Okay, this dispute turns on an exception that arises when police believe evidence is being destroyed or some other emergency is underway. Wednesday's question was whether police may enter a home based on those exigent or urgent circumstances, if officers have essentially created those circumstances, for example, by causing occupants to panic and move to try to destroy evidence. A common scenario raised Wednesday involves suspects who hear police at the door and quickly flush drugs down the toilet. Now listen, if I'm at home and there are 4 or 5 police officers banging on my door, there's going to be a commotion in my house. It's not going to be to flush drugs down the toilet, I tell you that, but it'll be running around. What are they doing here? What is their purpose? What is going on? So, you know, I guess that means that they could come and break in my door because they heard a noise from the inside. Here's what happened to cause this. Back in Lexington, Kentucky in 2005, they entered an apartment building looking for a man who officers said had sold crack cocaine to an undercover informant and then fled. In the apartment breezeway, officers heard a door slam but did not know which of 2 units the dealer had entered. They said a marijuana odor was coming from one of the doors. So they did not see the suspect enter any of the doors. They just heard a door slam. It sounds like a breezeway, so it's an open way. Who knows? Maybe that suspect ran on past those doors and maybe somebody that's living there just shut their door at that moment. So if they shut the door, it probably haven't helped them. Let's read on. Officers knocked there, announced that they were the police, and then broke down the door. Police found Hollis King and 2 other people inside with marijuana and cocaine. The dealer, whom police were seeking, was not in that apartment. He was in the other unit. Okay, so here we have these people in their own apartment, minding their own business. You know, I don't know what they're doing with those drugs, if they're consuming them or if they're packaging them up. We don't have enough information in that article. But the point is here is that they were in their own apartment. They were not involved in the situation. They were not suspects, but the police felt the duty to bust open that door and go in there, and then they find them with marijuana and cocaine. Now, many times court cases like that have been thrown out because I think it's called Fruits of the Poison Doctrine or Fruits of the Poison Tree. You know, I'm not a lawyer, but I remember something about that. They didn't have actual probable cause to go in, and so the evidence was suppressed. But let's read on here. King, who was in that apartment, objected to the evidence from his apartment being used at trial because police lacked a warrant to enter. The judge rejected his move to suppress, and King was sentenced to 11 years for trafficking of a controlled substance and marijuana possession. Now, it says he's trafficking controlled substance. I don't know what constitutes trafficking. I have no idea. We don't have enough information in this article to find out, but the police break into the wrong place, and this guy is facing prison for 11 years. Crazy. I don't know. On appeal, the Kentucky Supreme Court ruled that the evidence should not have been used because police did not have a warrant and that the emergency circumstances police cited were of their own making. Right. Awesome on the appeal. The state court said officers would have foreseen that their tactics at the door could have caused noise and commotion inside. Exactly. As I stated before, if there's some officers knocking on my door, there's going to be some noise and commotion inside. But listen to this one. Oh, okay. The officers had justified the entry by saying they heard noises that led them to believe the occupants might be getting rid of illegal drugs. So, in that case, officers knock on my door. I happen to be using the restroom. I flush the toilet to answer the door. Obviously, I'm getting rid of illegal drugs. Boom, in they come, and without a warrant. Backing Kentucky's appeal are the federal government and 34 states. Kentucky officials say the lower court ruling would impinge police action and reward criminal behavior. See that psyop? See that spin, how they're taking our Fourth Amendment, demonizing it, telling us that it rewards criminal behavior. Ladies and gentlemen, this is how they operate. They are going to get people convinced that if you don't give up your rights, you're a criminal. And most of the American people are going to roll right over and say, come on in, officer. Go ahead and break down my door. At least I'm safe. You're keeping my neighborhood safe. Thank God that you're violating my Fourth Amendment. We need to get rid of that. That's what they are doing here. And that's how the spin operation works. It makes me sick, to tell you the truth. Let's see. Kentucky Assistant General Joshua Farley told the justices Wednesday that the marijuana odor coming from the apartment would have given officers probable cause to obtain a warrant from a magistrate judge. That's right. Probable cause to obtain a warrant, not to break in the darn door. But, he said, after an officer knocked and sounds of possible destruction of evidence were heard, the situation became urgent. I'd like to know what these noises are because I don't want to commit those. I mean, if a police officer's walking by my home or my front door and hears a strange noise, does that give him a right to come in and just bust down my door? I don't know. But it looks like that's how it's going. Representing King, Jamesia Drake told the court, the odor of burnt marijuana coupled with an officer's cursory and equivocal testimony about the sounds of movement is insufficient to establish exigent circumstances. Correct. She argued that police violate the Fourth Amendment if officers have conveyed the impression that entry is imminent and inevitable. As the justice struggled with proper tests for when police are exempt from the warrant requirement, such as Kagan emphasized the importance of preserving Fourth Amendment safeguards against unreasonable search and seizures. She asked whether all police would have to say is, we heard noise. That's my question. That's my fear. Ladies and gentlemen, what they're doing here is starting to blur the lines. Once they blur those lines and they step over that line, it becomes common practice, and then we are doomed. We need to stand up. We need to stop this kind of thing right away. We need to contact our senators, our congressmen, our elected, I hate that word, officials. Elected servants is what they are. They are not our officials. They are not our bosses. They are our employees. We are the ones that pay for them to do what they do. So, ladies and gentlemen, let's stand up. Let's start calling these people. Let's make sure this is in proper order. Let me see if there's anything else important in here. Yes. Okay, let me read the last quote. This court has never required police officers to abstain from lawful investigatory conduct or obtain a warrant when it is foreseeable that a suspect will react illegally to a lawful request for cooperation. Government lawyers told the court in the brief. Illegally to a lawful request for cooperation. What is a legal request for cooperation? Is it, sir, can I see your ID? For what reason would be my question. You know, if I'm not committing a crime. See, this is blurring the line, as I said before. This is leading us down a slippery slope into some very dangerous territory. Ladies and gentlemen, it is incremental. It's a little bit at a time. And I know most people will look at this and say, oh, just, you know, I will do it for my safety and for my children. Ladies and gentlemen, we need to protect our Constitution. We need to protect our Fourth Amendment. Now, be very careful about talking to people about the Constitution and Fourth Amendment. They're demonizing us for people that want to see a government run or see a government held accountable. They're demonizing us as extremists and crazy nut jobs. So just be very careful. But let's wake up. Let's talk to our congressmen. Let's talk to our elected representatives. Let's get it done. God bless America. I'll see you on the other side.
Don't tread on us, we're not afraid. You work for us, we're not your slave.